Hello there and good morning. Just so you know, Section 20 of the EU Withdrawal Act 2018 has been amended to say that the date for our exit from the EU has been changed. But strangely, the date is not specifically stated. It uses the text from the statutory instrument instead of putting in the correct date that resulted from the decision by the House of Commons to reject Theresa May's deal. So instead of saying that the exit date is now 11 p.m. on the 12th of April 2019, it says there is a choice of two dates, the 12th of April or the 22nd of May. Why not just put the one correct date in? Unless maybe there is a legal loophole no one else has spotted yet? Now, yesterday I talked about a legal action being brought by the chairman of the English Democrats, lawyer Robin Tilbrook, arguing that the Brexit Article 50 extension the government negotiated without first gaining parliamentary approval was unlawful, which could potentially make that exit day change I just talked about null and void. And Tilbrook is not the only lawyer who thinks that the government has a case to answer here. Writing in briefings for Brexit, the Right Honourable Sir Richard Akins, who is a former member of the Court of Appeal and former Vice President of the Consultative Council of European Judges, also makes the argument that the government may well have acted unlawfully in this. Considering how the government negotiated with the EU on the matter and said it had made an internationally binding agreement with the EU that Parliament would now have to follow, Akins says, "In trying to force Parliament to agree to this unilateral act taken without prior parliamentary approval, it may be that the government has acted illegally." And he says that the law is quite clear in that non-binding negotiations should have been conducted with the EU prior to any statutory instrument being laid before Parliament. Then once the statutory instrument was agreed, the government could formalise the arrangement. He also says that the government and the UK permanent representative to the EU, Sir Tim Barrow, do have the power to make such commitments for the country, but that power is limited. And he says that if his argument is correct, then the actions of HMG through the permanent representative cannot bind either Parliament or the UK generally on the international law plane, so that any purported extension of the Article 50 period would not be valid. And he ends with, "It must be arguable that the government has acted illegally." My question would be, what are the legal remedies and punishments available to the rest of us for what could be the flouting of the law of the land on such a grand scale? And what is worse, the vast majority of our parliamentarians, both MPs and Lords, refused to exercise their supposed parliamentary sovereignty and voted with the government when that statutory instrument was finally placed before them after the fact. And they did it to ensure they had some more time inside the EU to try and reverse the Brexit process. But today our MPs are enforcing their parliamentary sovereignty by taking charge of the order paper once more to try and use the indicative vote process to find a consensus on a way forward that will reverse the Brexit process. So they enforce parliamentary sovereignty when there is a chance to reverse Brexit, and give up their parliamentary sovereignty when there is a chance to reverse Brexit. Anyone see the pattern here? Anyway, what do you think? Please share and comment, and thank you for watching.